So, Glenn, as you look at the overall picture and the impact that this could have on the other overall picture, are we well past the point that we were talking about for so many months, which is that these trials are kind of going to depend on one another? There could be a kind of domino effect. When something happens one place, it impacts the other place. It almost looks like none of that is relevant, at least as we're looking toward the election.
You know, it does feel less and less likely that we're going to get any case other than, obviously, the New York case, which is underway, any of those other cases to trial before the election. I agree with Ken. It's not impossible that we could have at least a first RICO trial down in Georgia before the election. I also think it's unlikely, but let's also keep our eye on the fact that when these big RICO cases end up going to trial, it's not unusual. This was my experience when I was prosecuting RICO cases, for a trial to be set with just a handful of the defendants, and there are 15 charged defendants that remain pending trial in Georgia. So I wouldn't rule out the possibility of perhaps a September trial against a modest batch of defendants down in Georgia, maybe 3, 4, 5 of the defendants. Of course, it could include Donald Trump. But Chris, as you say, there are cases being played one against another. There are so many moving pieces that I think it becomes harder and harder to see how one of these cases actually make it to trial, other than the one in New York before the election.
So let me ask you a little more about what's happening in Florida and Judge Aileen Cannon, who, of course, is overseeing that classified documents case and who postponed that trial. The New York Times put it this way, Glenn: a bare bones order that contained no factual or legal reasoning. She has faced criticism of bias before. Does this raise bias issues for you, issues of competency, or is it, frankly, within the realm of any judge's right to do what they want to do and rule how they want to rule?
Chris, it raises all three of those things you just cited. I would put this as additional evidence and information into the recusal bucket. Here's why I say that. Often as a prosecutor, I would have defense attorneys urge judges not to set a trial date. They would say, Judge, we still have so much pretrial investigation we need to undertake. We need to file and litigate motions. We need those motions to be resolved well in advance of trial. So please, Your Honor, don't set a trial date. I can't recall ever having a judge fall for that, because everybody in the system understands you have to have a set trial date, a firm trial date, and then you set all other intermediate deadlines for filing and litigating motions in place in the run-up to that trial date. You need a trial date to subpoena witnesses and have enough time to prepare witnesses. So when I saw Judge Cannon refuse to set a trial date, mind you, this is against the backdrop of when she last asked the parties, the prosecution and the defense, for proposed trial dates. Jack Smith proposed July. Donald Trump and his attorneys proposed August. And she is unwilling to even set the proposed date by the defense, August. She said no trial date will be set. I think it's further evidence of her determination to put this thing not just on a slow track. It almost feels like she's trying to catch and kill this case, apropos of what David Pecker was doing, trying to help Donald Trump in the 2016 election when he was catching and killing negative information about Donald Trump.